So as Siobhan was saying, I have just finished my PhD, and it was on the Mental Capacity Act. I feel like I should explain that actually I came to do my PhD because I was so concerned at the way the Act was being used in care settings by psychologists and so on to really subordinate people's will. And it really has quite controlling effects in care settings. So that was where I came to with doing this PhD. The Mental Capacity Act is quite a popular act. In England, you'll often hear people saying it's very empowering, it promotes autonomy, and I don't agree with that. And I want to talk to you about a very specific bit of the act. It's quite a complex act in some ways, but I want to talk to you about how it deals with legal capacity. So I'm just going to quickly remind you of a distinction that Eleanor and Anna talked about, which is between mental capacity and legal capacity. Mental capacity is this hypothesised construct under acts like the Mental Capacity Act and similar acts of what's going on in your head when you make a decision. It's kind of a set of functional attributes, pseudo-cognitive criteria that we think underpin, or some people think, underpin decision making. So mental capacity, what people think is going on in your head. Legal capacity is the way other people respond to you in terms of your legal decisions. It's whether or not people recognise the outcome of your decisions as legally binding. Under functional approaches like the Mental Capacity Act, your legal capacity, so that's how other people respond to your decisions, is hitched to your mental capacity, which is what they think is how you made the decision, what's going on in your head. So under the Mental Capacity Act, mental capacity and legal capacity become the same thing because people only treat your decisions as legally binding if they think you have mental capacity. And the reason Article 12 is so radical is because it blows these two apart. It says, forget about mental capacity, stop asking what's going on in somebody's head, and respect the outcome of their decision. So legal capacity exists regardless of mental capacity. Now, I'm going to use the phrase mental capacity a lot today, and I'm talking about this hypothesised thing, which under acts like the Mental Capacity Act are the gateway to legal capacity. But that doesn't mean it always has to be the gateway, it just means it is in this legislation. Okay. So, it's quite hard to fit the Mental Capacity Act onto two slides, but I've tried. The basic function of the Mental Capacity Act means that people are allowed to make third parties can make decisions on your behalf in your best interests or what they think are your best interests if they are satisfied that you lack this thing called mental capacity. And mental capacity is measured by a functional test, which I'll go into on the next slide. Best interest decision makers under the Mental Capacity Act can be a whole range of people. So the first person, or the first body that can make best interest decisions on your behalf is this court that was specially created under the Mental Capacity Act called the Court of Protection. And the Court of Protection, so I could apply to the Court of Protection and say, I think so-and-so lacks the mental capacity to make this decision, what do you think is in their best interests? And the court will conduct a kind of inquiry, it's sort of adversarial, sort of not, about whether they think that you have the mental capacity to make this decision and what they think is in your best interests. And they can make an order that's in your best interests. Now, the really controversial cases around things like abortion, sterilisation, withdrawal of life-sustaining treatment are meant to go to court. But actually, only a very small proportion of cases are decided by the court this way. The court is really a substitute decision maker of last resort. Much more commonly, the court will appoint somebody called a deputy to make decisions on your behalf. Now, a deputy is kind of like what we mean by a partial guardian in other jurisdictions. It's somebody who has a limited range of powers to make decisions for you in your best interests. Usually, in the UK, or in England and Wales at least, deputyship is only used for financial and property decisions. You can create deputies to make health and welfare decisions, so that's decisions like where a person lives, what medical treatment they should have, but this is really rare. Now, the reason this is really rare is because the law also has something called the general defence. The general defence means that if somebody reasonably believes that you lack capacity and that a particular course of action is in your best interest that's connected with your care and treatment, they have a defence against litigation that you might bring, perhaps under the torts of trespass or human rights law. They're kind of immune from liability, so long as they can show that they were satisfied that you lacked capacity and that the course of action was in your best interests. Now I find this quite scary. This is really quite an extraordinary power. I'll give you a couple of examples. Your doctor might think that some treatment that he's in a position to provide is in your best interests, and you might refuse that treatment. If your doctor is satisfied that you lack the mental capacity to make that choice and that the treatment is in your best interests, he would be protected against you litigating him for battery when he then gave you that treatment. So there's no need for him to go to court. He can just do it. A social worker might decide it's about time you moved into a care home because you're no longer safe at home. Unless they need to access your finances, which would require some kind of formal authority, like a lasting power of attorney or a deputyship or a court order, they could make the decision to move you into a care home in the face of your objections without any formal legal authority under this general defence. Now, there are some fuzzy edges to when these cases should go to court, but they go to court very, very rarely. The vast, vast majority of health and welfare decisions under the Mental Capacity Act are made on this very, very piecemeal, informal basis. This means that the people determining your mental capacity won't be a single deputy. They won't be a court. They could be any number of people. They could be your doctor, your social worker, your care worker, a whole range of people. And that's really important to understand when we go on and think about the process of assessment. Okay, this is what the functional test looks like under the Mental Capacity Act. The test defines mental capacity as the ability to make a decision for yourself. And the ability to make a decision for yourself, according to the Mental Capacity Act, consists in the ability to understand the information relevant to the decision, the ability to retain that information, to use and weigh that information as part of the process of making the decision, or to communicate that decision by talking, using sign language or any other means. If you lack any of these criteria in relation to that particular decision, you'll be said to lack mental capacity and others can make best interest decisions on your behalf. Now, it's not what you might call a pure functional test because it's hitched to something approaching a diagnosis. It's not just enough that you lack these functional abilities. You have to lack them because of an impairment of or a disturbance in the functioning of mind or brain. This is quite interesting because research by people like Rousseau and Applebaum have found that actually large numbers of people who have no mental impairment fail the functional test. They won't be picked up by the Mental Capacity Act because their lack of functional ability is not caused by an impairment. I think there's really interesting questions around whether that's discriminatory. Is it even a question? But I'm not going to go into them here. Okay, this slide is just to remind me to tell you that mental capacity under the Mental Capacity Act is very, very fragmented. What I mean by this is there isn't a single gateway to loss of legal capacity. It's not a case that a court determines once and for all whether you have capacity in all or no matters. Your mental capacity could be called into question in a huge range of contexts. This slide is really a subset of lots of slides which should come off from all the different points. So let's take the machinery of justice. Your mental capacity to instruct your solicitor might be called into question. If you are seen to lack the mental capacity to instruct your solicitor by your solicitor, a litigation friend will be appointed to instruct your solicitor on your behalf in your best interests. And they may run a case in your best interest that's actually not the case you want them to run. So they might argue, for example, in a recent case about anorexia, that you should be force-fed in your best interest, when the whole reason you want to go to court is to say you don't want to be force-fed. Your property and affairs could be called, your mental capacity to manage your property and affairs could be called into question. We also have a framework for deprivation of liberty under the Mental Capacity Act called the Deprivation of Liberty Safeguards. Your capacity to marry, to consent to sex, to choose who you have contact with could be called into question. And all of this can happen on a very fragmented basis. Each of these decisions will be taken, in theory, in isolation. It's kind of like a weed. You can show you have mental capacity in one area and the question will just pop up somewhere else. So in this talk, I don't hope to cover everything to do with the Mental Capacity Act or even every nuance of functional capacity. I just want to leave you feeling unsettled by the concept of mental capacity. And I'm going to do that by first of all saying, just stop for a minute thinking about mental capacity as this really obvious thing that goes on inside our head. and focus not on what's going on in people's heads, but when their mental capacity is being called into question. What social and legal work is this concept of incapacity actually doing, and what's it enabling us to do? So in order to do this, I want to look at how and when functional capacity is called into question and assessed. I want to think about what it feels like to have your mental capacity be assessed. And then I want to go on, hopefully if I have time, to challenge the notion that functional capacity is value neutral. And if I don't have time to get through all these because you have lots of questions, there is a reading list on the Dropbox with some great papers written by much cleverer people than me that you can go to. Okay, when is mental capacity assessed? There have been a few really good empirical studies of the Mental Capacity Act that were published last year. I'm going to talk about them throughout this talk. So EMIT is a small-scale, 30 people or so ethnographic study. Ethnographers are people who kind of hang out and interview lots of people and find out how they think and what makes them tick. And they hung out in a hospital department where people with dementia were admitted, and they looked at processes around discharge and whether people were allowed to go back to their own home or whether they were bundled off into a care home. That's a really, really good paper. The study by Williams et al. Is one of the most comprehensive studies we've seen of what's happening with the Mental Capacity Act on the ground. I urge you to read it. It was sponsored by the Department of Health, and it involved interviews with hundreds of practitioners, or interviews and surveys with hundreds of practitioners. I'm going to say at this point, to the best of my knowledge, there is literally no research on how people who are alleged to lack capacity feel about the Mental Capacity Act. That's a massive and fascinating gap in a booming literature on the Mental Capacity Act, but it's one, unfortunately, I haven't been able to remedy just yet. Anyway, empirical studies show that mental capacity assessments come up when people are making a choice that we don't like. That's fairly predictable. But what's interesting is that we find that people's mental capacity is not called into question, perhaps when it should be, according to the law, when they're making a decision that we do like. So the Care Quality Commission are responsible for monitoring a law called the Mental Health Act in the UK. Under the Mental Health Act, you can do what you want to people for the first 3 months, but after 3 months, if you want to give them medical treatment, either they must give their capable consent, or you need to get a second opinion appointed doctor to confirm that it's the right treatment for them. And year after year after year, the body responsible for monitoring the Mental Health Act say, where people are compliant with the treatment that's being administered to them, doctors don't consider their capacity because they don't want to have to go to the trouble of getting this second opinion appointed doctor. So it's a kind of strategy.
Excuse me, can you go a bit slow?
Oh, sorry, yeah, I'll slow down. Okay. Does anyone need me to repeat anything?
Yeah, at least...
Last slide? Last slide. Okay. To summarise the last slide, empirical studies and regulatory reports show that a person's mental capacity to make a decision is called into question when they're making a decision we don't like. When people make decisions that we do like, we tend not to worry about how they got there. We tend not to question their mental capacity. And this has led researchers or writers like Sabatino and Wood, which was quoted in a great paper by Judge Booth Glenn, to call incapacity a legal fiction. So it's a legal fiction to tell us when a state legitimately may intrude into an individual's affairs and take action to limit an individual's rights to make decisions about his or own person or property. And part of the reason we want to intervene in people's affairs, and this isn't by any stretch the only reason, but it's perhaps the most defensible reason, is to do with this thing called the protection imperative, which judges in the Court of Protection worry about. So the protection imperative is where we see someone doing something that we think will bring some harm about, and we desperately want an excuse or a reason or something to legitimate an intervention which will stop them making this choice that we don't like. And incapacity offers us that opportunity. And judges of the Court of Protection repeatedly raise concerns that people have fudged capacity assessments in order to be able to intervene. Now, Article 12 doesn't even have a concept of a good capacity assessment, but I think we do need to still take the protection imperative seriously in various ways. We need to be thinking about other strategies which are consensual to support people. We also need to look at how best interests and substituted decisions are creating these situations of risk. And we need to accept that sometimes people have a right to make risky choices. They have a right to refuse to be protected, and people with disabilities should enjoy that right on an equal basis with anybody else. I want to stop and think now about what it feels like to have your capacity be assessed. So this is what Her Honour Judge Hazel Marshall said about capacity assessments. Consider the implications of taking a test where you're judged by standards you know nothing of, you have no idea what are or are not the right answers, and the result of not passing may well be to have control of your affairs and destiny removed from you. So Susan Stephan is a feminist scholar. I'm going to read to you a quote of hers from this slide. It says, "Far from being an internal characteristic of an individual, a judgment of incompetence is a judgment by those in power that the conversation has broken down. Often the failure of communication is due to the dynamic between two people." When we talk about mental capacity, we almost automatically assume it's a characteristic of an individual and it's something going on inside their head. But if we stop and think about the dynamics of capacity assessments, we realise that the outcome of that assessment is very, very contingent on the relationship between the assessor and the person being assessed. There are a whole range of relational factors which can influence the outcome of that assessment. So it might be that the assessor is pressed for time. The assessor may lack the skills necessary to communicate with the person. The person might not like the assessor, might not like this nosy person prying into their life. The assessor may well have a different set of cultural and social values and understandings which may influence how they understand what the person is saying, or they may not understand the person's communication method. But the point is, where the assessor feels that the conversation has broken down, is the consequences fall to the individual who's said to lack capacity, not to the assessor. On the slide is a quote from a case called RT and LT. It's not a particularly important case, but it's one of very, very few cases under the Mental Capacity Act where we actually have some quoted text from the capacity assessment. So very often the court won't actually meet the person who's said to lack capacity. They'll rely on assessments by experts. So the quote on the slide reads, "Miss Marcus put to Dr. K that he had not really given LT the opportunity to go back and identify the negatives. This was the negatives with a return home. LT lived in a children's home and she wanted to go and live with her family. And in order to do this, she had to demonstrate her mental capacity to make that choice, and the doctor decided that this meant she had to identify the negatives of a return home." So Dr. K responded to this question that he had tried, but he'd been met with "don't knows" and "I want to go home, why don't you understand that?" Now, I think that last sentence in the passage I've just quoted is really, really striking, because the outcome of this capacity assessment was that LT didn't understand. But actually, isn't it the assessor who didn't understand LT, who couldn't empathise and understand her reasons for wanting to live with her family? But it's LT who couldn't go home. As I said, I wanted to find some research to share to you how it feels to have your capacity be assessed. And perhaps my literature review skills aren't very good, I couldn't find any. So I thought I'd do the best I could with a story, and this is a story about two heroes of mine, Stephen and Mark Leary, who are in the picture on the slide. So Stephen Leary is a young man who lives with his dad Mark. And about 3 years ago, Stephen went into respite care because his father had flu. He became very distressed in respite care. They tried to break down his routine. Stephen had autism and he found this incredibly difficult, these people trying to break apart his routine and make him more flexible, and he lashed out. So it was decided that he couldn't go home, that he lacked the mental capacity to go home, and it took his dad a year to get him home. And this experience has been incredibly traumatic for Stephen, but the court did finally find that he had been unlawfully deprived of his liberty under the Mental Capacity Act. 3 years later, in part because of Stephen's damages for being unlawfully deprived of his liberty, the family are about to be made homeless. Mark writes a blog about his experiences of the social care system, and I really, really encourage you to read it actually. It's one of the most insightful things I've ever read on the social care system in the UK. And Stephen, because they're about to be made homeless, might become the tenant of their new home. So the local authority, for some reason which actually isn't entirely clear, decided they needed to assess Stephen's mental capacity to enter into a tenancy. I'm going to read to you what his father wrote on his blog about this assessment. The absence of echolalia is a symptom or a sign where people just mimic back what's said to them. So they don't... Okay. So the absence of echolalia is a sign to me that things are going well. The presence of it indicates a problem. And usually it's framed that the problem is with Stephen. It couldn't possibly be that the problem is with the person communicating with him. It's a shame though, isn't it, that the only outcome of a mental capacity assessment is to trigger this typical autistic sign of deep anxiety that he had outgrown many years ago. Now, as I said, there isn't comprehensive research on how it feels to have your mental capacity be assessed. But this story and other stories that I could share with you certainly suggest that it's quite a traumatic experience for at least some, if not many people. Okay, and I want to go on to my fourth topic for discussion about the value neutrality of functional capacity. So one of the attractions of the functional approach to capacity is that it's supposed to be value neutral. Now this is contrasted with outcome approaches, which Anna and Eleanor talked about. So the idea is that whether or not a person can make a decision shouldn't be about what decision they actually want to make, it's about how they made the decision. And Veitch, who's a great writer who I'd recommend, who I might be pronouncing wrong, says that we like this because it allows us, as members of the judiciary, to declare that we're not involved in making value judgments about people's proposed courses of action, nor in making explicit decisions about life and death. We're just talking about what's going on in their head, aren't we? We don't care what they would decide. And the Mental Capacity Act has a safeguard built into it against outcome-oriented assessments. It reads, "A person is not to be treated as unable to make a decision merely because he makes an unwise decision." And this is meant to guard against outcome approaches. But the empirical studies that I described to you at the beginning of the talk repeatedly find that we're not very good at doing this. So Williams and colleagues, so this is this big Department of Health sponsored study, said unwise decisions were very hard to disentangle from an assessment that someone lacked capacity, especially when the assessment was made on the basis of lack of understanding of one's own needs or protection for care, or protection or care. The other study by Emmett found the same thing. Professionals from a range of disciplines explained how it could be difficult to unpick whether a patient lacked insight into his or her situation and therefore could not weigh things up properly, or whether the patient was being simply unwise. On the slide are two quotes from a case called CC versus KK. This is a really, really important case under the Mental Capacity Act. Astonishingly, this is the first published case in 5 years since the Mental Capacity Act came to court where somebody has successfully gone to court saying, "I have capacity," and the court agreed. There have been other cases where people had capacity and they've got their other ways, but this is the only time a person has actually managed to apply to court by themselves to assert their capacity, which raises a whole load of interesting access to justice issues. Anyway, in this case, Mrs. KK was in a care home and she didn't want to be there. She said the food was diabolical and she missed her home and she wanted to go back to her bungalow and be surrounded by her things. And 3 expert assessors of capacity had come to the conclusion that she lacked the mental capacity to make this choice. Now, very, very unusually, the judge in this case actually met Mrs. KK and asked her, why do you want to go home? What's wrong with the care home? Have you thought about the risks? Now, the local authority had said KK's awareness of her care needs is superficial. When the judge actually said to her, "Have you thought about how risky a return home might be?" Mrs. KK responded, "If I die on the floor, I die on the floor. I'd rather die in my own bungalow, I really would." Now that sounds a lot to me, and it sounded a lot to the judge, like a situation where it wasn't so much that she didn't understand the risks, it was more that she was prepared to tolerate risks that the rest of us would rather that she didn't. There are other situations that arise where it's very, very clear that the outcome of a person's decision is what's contributing towards a finding of incapacity. And anorexia is typically given in the critical literature, so there's a lot of readings that I've given you in your reading list from this critical literature, of a situation where the outcome of a person's decision, so that's a decision to refuse food or refuse treatment, is seen as a key factor in whether or not they're said to be capacitous. In effect, you cannot both have capacity and refuse to eat. The outcome is entirely determinative of your capacity. So we had a case recently called Re about a young woman who'd had anorexia for about, one or maybe two decades, who was refusing treatment. She'd made two advanced decisions refusing treatment with support from an advocate, her mother, and a lawyer. And the expert in the case said that anyone with severe anorexia would lack the capacity to make such a decision. The treatment that was proposed was only given a 20% chance of success. That's an 80% chance that she would die whilst being force-fed. And the court found that she lacked the capacity to refuse this treatment with such dismal prospects of success and such an unbearable process, and it was ordered that it was in her best interest to undergo it. But I don't want to suggest that it's always straightforwardly the case that when people with disabilities make decisions that people don't like, that they're found to lack capacity. I think that would be too simplistic. But what I do want to say is that in those published cases where people have been found to have capacity to make a problematic choice, so Mrs. KK returning home possibly to die on her floor, other cases where people, for example, have refused amputations, which was thought to be necessary to save their lives, one of the common threads through these cases is that the people who are found to have capacity to make these difficult and painful decisions tend to have fairly good verbal fluency and narrative skill. They're fairly good at conjuring an argument for why they should be allowed to do this, constructing a kind of bittersweet ending to the narrative. Morgan and Veitch have a really useful quote that highlights this, I think. They write, "The real point of legal tests for mental capacity is not to be to assess some projected future or indeed past ability to make a choice, but to assess whether the person making that decision can construct a convincing case why he or she reaches the standard of ability that the law expects." So what capacity assessments on this view are assessing is not how we're making a decision, it's how we justify our decision and how good we are at justifying our decisions. Oh, 1 minute, well that's good, it's almost the last slide. And that's really important because a lot of people with different impairments may find it difficult to communicate, may find it difficult to be persuasive. And this means that these kinds of tests will really, really penalise them. Now, research that I haven't listed on the slide and haven't put in the readings, but which I can tell you about if you're interested, suggests that most of us make our decisions on the basis of gut instincts, emotions, all kinds of irrational reasons. And we only conjure up a rational explanation for our decisions when we're called upon to do so. And psychologists who manipulate variables have shown that often it actually bears no resemblance to the explanation that would explain our patterns of behaviour. So our explanations for why we've made a decision in ordinary circumstances often actually have very little insight into things that influence the outcomes of them. And my question is it fair that people with impairments of the mind or brain should be called upon to exhibit a higher standard of decision-making, which psychologists think probably doesn't even underpin decision-making, than the rest of us? Okay, I have 2 summary slides, but I'll spare you those.
Well, if you stay there, Lucy, what I'm going to suggest is that Lucy, then the 3 next sets actually speak, and then we have a question session at the end. I just want to thank Lucy for an absolutely powerful piece, and yes, I am uncomfortable.
So Anna and I are going to talk about the Irish process of law reform around legal capacity, and we're going to try to get through a quick explanation of the current law for those of you not familiar with it, talk about the time frame of reform, and I'm going to try and do those parts, and then Anna's going to talk more about the process of bringing a coalition of organisations interested in legal capacity reform together, which we did in cooperation with Amnesty, and the process of building that coalition and the lessons that we learned. And if we have time, we will tell you more about the principles that we came up with at the end of that process. And we actually have copies of them down the front if people would like to have a look at those. So that might be useful. Yeah.
And I just kind of wanted to highlight before we get into it. So this we kind of entered the reform process about 2 years ago now, actually, in Ireland here. And what our goal really was to avoid getting exactly what Lucy talked about from the MCA, because there was an instinct in Ireland to kind of grab onto what the reform, which is relatively recent, is in England and Wales, and to just transplant that here and use that. And we panicked, and for all the reasons that Lucy just described, we wanted to do everything we could to try to stop that from happening. So that's how we kind of entered into this law reform journey that we're going to tell you about now.
I'm not going to spend too much time on this, just to say that in terms of deprivation of legal capacity, in Ireland the only way to do that right now is to have a person made a ward of court, which is something that can be done under some really antiquated legislation from the Victorian era, ironically called the Regulation of Lunacy Ireland Act. And the definition of a person who can be made a ward of court is a person of unsound mind. It's not any further defined than that, who is incapable of governing his person or property. And generally evidence from 2 medical experts as to the person's unsoundness of mind is required. Once you're found to be unsound of mind and incapable of governing yourself or your property, a committee of the ward is appointed. A committee is sort of deceiving here because it's usually one person, so that's why I've sort of analysed it to guardianship. Often it's a parent. Alternatively, the High Court, which makes the decision about whether someone is made a ward of court, can act as the committee of the ward and make a decision. So based on what we talked about earlier in terms of the different approaches to deprivation of legal capacity, this would be a status-based approach, akin to what's called plenary guardianship in other jurisdictions. The person is no longer recognised as a person before the law. Effectively, they're not none of their decisions can be legally recognised once they're made a ward of court. They have no decision-making power in any area of their life, although, because we all recognise that this is so awful, enforcement is weak, and so especially people who have supportive parents who are made wards of court do actually make decisions in parts of their life, but legally speaking, that's really not possible. And just to say as well about mental health law, and again, I'm not going to spend too much time on this, but it's very relevant to capacity law reform. In Ireland, we currently have a system of involuntary detention and treatment. Our 2001 Mental Health Act talks about voluntary and involuntary patients who may be detained in approved centres, which is essentially psychiatric hospitals. Detention can occur if the person has a mental disorder, which within the Act includes a type of impairment, but also the risk of harm to self or others. And as long as you have been certified by a doctor to have a mental disorder and this is confirmed by a second medical opinion within 24 hours of detention, your detention can be valid. The Act then contains a whole set of safeguards around if you are detained, how you can challenge that, how it must be reviewed, and so on. And generally this is done through a process of mental health tribunals, at which it is decided whether your detention is still necessary, not whether the particular course of treatment is the correct one or is permissible, and also the person is entitled to independent legal representation at that tribunal. So the reform journey, where do you start? Well, we decided to start the conversation with the publication in 2006 of the Irish Law Reform Commission's report on vulnerable adults. There had been a consultation paper in 2003, and it says 2006 here, but really I suppose in terms of the timing of this, it's important to note that the CRPD was finalised at the end of 2006, and so there was a gap between the Law Reform Commission's report being published and before we actually knew what the final wording of Article 12 would be or thought much about what that would mean. So because of that, in part, the Law Reform Commission recommended adopting essentially an approach which would reflect the Mental Capacity Act in England and Wales to a certain extent, except with, instead of what Lucy described, which is where almost anyone the person interacts with can make a best interest decision for them under the general defence, there was going to be more safeguards around that. There would be adult guardians appointed to make substitute decisions, and those decisions were capable of being reviewed, the Law Reform Commission suggested, by an independent tribunal, not the courts. And essentially they proposed the functional assessment of mental capacity as Lucy explained it, which currently exists in the Mental Capacity Act. But it also allowed for informal decisions to be made about things that weren't thought to be particularly significant day-to-day decisions about a person's treatment or care, which maybe would have ended up then being something like what's happened with the Mental Capacity Act. In 2007, Ireland signed the UN Convention, and in 2008, the government published the scheme of the Mental Capacity Bill. So what this means is it wasn't the official act, it's not even really a draft, it's more the heads of the different sections with some explanations about what would be contained in the bill. And largely this followed what the Law Reform Commission had suggested. So it set out a functional test of mental capacity, it set out a system of adult guardianship. The only difference really, I guess, between that scheme and what the Law Reform Commission had suggested was that the government proposed that this whole thing be done through the court system, whereas the Law Reform Commission had recommended the establishment of a new, separate, independent tribunal with a range of experiences, including different professions, but also lay people. The great thing about that that came out of after this scheme was that the Department of Justice had to do a regulatory impact assessment to decide what the impact of that law would be. And in that, they mentioned that this law will be needed in order for Ireland to ratify the convention. And I guess that's where our whole advocacy campaign started. Because now they had linked the reform to Article 12. And we decided that, okay, well, it's actually quite a long way from Article 12, and we needed to think about how it could be different. So after that, not much else happened for quite a while. There were some private members' bills introduced in Parliament, which basically either took the form of what the Law Reform Commission had proposed or some version of the 2008 scheme. But private members' bills are very unlikely to pass in our Parliament, so they didn't. And then we had an economic crisis, and we weren't so worried about capacity for a while. So in the following 2 years, there wasn't much progress. Some conferences touched on this issue, and many organisations would repeat calls for action. But mostly the line was that, why hasn't Ireland ratified? We need to ratify the convention. And the response from the government was, well, we haven't changed our capacity law. We're working on it. When we finish that, we will then ratify. In February 2011, more due to the economic crisis than concern about capacity, there was a change of government. And luckily for us, in the programme for government, there was a commitment, there's just one line that said this government commits to bring forward capacity legislation that will enable Ireland to ratify the CRPD. So again, we latched onto this and we used that as an advocacy tool to say, if the purpose of this legislation is to enable us to ratify, then it must be compliant with what the CRPD is asking you to do, and a straightforward functional assessment of mental capacity and adult guardianship regime, as was proposed in 2008, is not going to achieve that aim of enabling us to ratify the convention. So then in August 2011, the Justice Committee of our Parliament called for submissions to the committee on what the capacity legislation should look like. It was an open call, and everyone panicked because it was in August, in the middle of the summer, and everyone was on holidays, and we all had like a very narrow time frame to get submissions in, but people managed to get some submissions in, and eventually the Justice Committee held hearings with some of the organisations who had made submissions almost a year later. So, am I going to do this, or am I going to hand over to you at this point? Yeah, so I'm just going to hand over to Anna to talk about how the coalition came about and some of the issues that we experienced during it.
So mentioned, and Eleanor did as well, we were panicking. It looked like this was going to happen really fast. It looked like there was going to be a bill that was going to be pushed through that denied legal capacity and also had the risk of potentially looking like the Mental Capacity Act in England and Wales, as Lucy described, and being very invasive into the lives of people with disabilities. And one particular challenge also was that there had been a need to change this Lunacy Act for many, many years, and disability rights organizations had been pushing for a change in this type of legislation for a long time. So many people were eager to get any kind of legislation out that would replace the Lunacy Act, which is obviously bad. And everyone agrees that the Lunacy Act is bad. That's not really controversial. The problem was that when we looked at the bill as it was not what we wanted at all. So we decided to build this coalition in conjunction with Amnesty Ireland, as I think Eleanor mentioned. And because we thought this was going to happen so fast, we actually didn't have a great master plan at the beginning. We just thought that we should bring as many people together, as many stakeholders and as many powerful disability rights organizations, as well as powerful people in the government that could be on side with us. We thought we should bring those people together and try to figure out what to do. So in September 2011, ourselves and Amnesty Ireland convened our first roundtable discussion with mental health groups, Mad Pride and, is that Acquired Brain Injury? IAN?
It's the Irish Advocacy Network.
Oh, Irish Advocacy Network, yeah. And intellectual disability groups, inclusion, older people, Alzheimer's, age action, brain injury, and then also mainstream human rights organizations. So we actually had a really great, broad range of people involved and that were interested. And in the beginning. And we met with all of them, and initially our main goal was to try to raise awareness amongst this group on Article 12, because it actually wasn't something that was well understood, and still really isn't well understood by a lot of people. So we wanted to first get everybody kind of up to speed on what Article 12 was and what the right to equal recognition before the law was, and then make a plan for what to do. So to do that, Eleanor and I, and Jared as well, tried to provide that education on Article 12. And then we brought in Christine Gordon from British Columbia to talk about coalition building. She did a Skype call to one of our meetings where we had all of our coalition there. And she was one of the leaders behind the Representation Agreement Act in British Columbia, which maybe some of you have heard of. It's a piece of legislation that allows for an individual to designate certain people to support them to make decisions. And they can also designate someone to make decisions for them if they like. But it places the power in the hands of the individual instead of the hands of the court or the state or a substitute decision maker. It's not a perfect piece of legislation, but there was, it's one of the only pieces of legislation that has supportive decision making within it. And there was an amazing grassroots movement that Christine Gordon was involved in that is what got the Representation Agreement Act passed and into existence. So we use that expertise from her to try to build this coalition. And before I pass it over to Eleanor to talk about the key decisions, I just want to say how important I think that coalition was, because it was not a single voice of what should be done in capacity legislation. It was a whole group of people that were coming from very diverse areas and had very diverse interests that were coming together to try to negotiate something. So in a way, we were trying to mimic as best we could with the resources we had, the process behind the convention that Rosemary talked about earlier today, to make sure that it wasn't just us as academics saying what we thought was the right thing to do, that we were bringing people together to make sure that what we were pushing for and what we were advocating was, as much as we possibly could, achieve the voice of people with disabilities in Ireland. And we'll talk more about that challenge.
Okay, we're not going to get to the principles. Okay, but we have copies and we can discuss them and read them later. And the roundtable tomorrow.
Giving them out.
Yeah, will be helpful for that. Okay, so the key decisions that we made in the coalition early on. The first meeting was interesting because a lot of us had tried to make submissions to the Justice Committee, and basically the first meeting, all we could agree on, we had very different perspectives on what we wanted the law to look like at that meeting from the different organisations, but we agreed that we did want the law to enable us to ratify the convention. That was as far as we got in the first meeting, and ultimately then out of that we decided, well, what would help us to get there? And we thought about drafting our own legislation, and at various points we discussed that, but we felt that wouldn't necessarily be helpful. It might be seen as too much of a threat to the actual legislative drafters. So we decided what we would do instead was develop principles for the legislation, and if all the coalition organisations could sign up to those principles, that would give them some good standing and legitimacy, and then we would publicise these principles and we would put them in the faces of the legislative drafters and the politicians and try to make sure that they took these into account when they were writing the law. So we wanted to influence the political process, that was clear. There was another key decision that we made. And again, to make the agenda that guardianship should be replaced with supported decision making. That was our goal. That might not have been the goal of everyone in the process, but that was our goal, and ultimately that is what the principles represent. And we wanted to build support for the idea of a legal capacity system, not a system based on mental capacity, which would lead to the denial of legal capacity. And we needed to do that among practitioners and service providers as well, because otherwise we wouldn't have the support needed to make sure that the law actually meant something in people's lives. So that was quite important to us. Given the time, should we try and rush through the different challenges? Do you want to do these together?
Yeah, sure.
So, time frame?
Yeah, so as I mentioned, we initially thought we had very little time because the government had expressed that the bill would be coming out very quickly. So we were rushing to get these things done, and we had a meeting every month for the first year almost, I'd say. It was very difficult to get everyone to attend these meetings because the different organisations are situated in different cities in Ireland, and we were having the meetings in Dublin, but it was still difficult to get everyone there. What we did do, and also because we thought we were under time pressure, was very quickly organise 2 separate international conferences where we brought in international speakers to basically raise awareness and try to get the points across that were coming out of the convention on the rights to legal capacity and the practice of supported decision making. It was probably good we thought that we were under time pressure because we were able to organize those pretty quickly in November 2011 and then April 2012. Based on those conferences partly, and the kind of, I think, momentum that it instigated, the Justice Committee hearings and the report coming out of it reflected a lot of language about the convention and about protecting the right to legal capacity as opposed to talking about when to infringe on the right to legal capacity, which is what the bill looked like initially. Do you Do you want to go stakeholders?
Yeah. And just to acknowledge as well, in terms of how we achieved this, there is no way we could have done this without Amnesty, especially Amnesty's backroom team that were constantly meeting with politicians and decision makers and policy makers and the legislative drafters and putting this in bullet point format for them in a way that they could understand in terms of what was needed, and that was really, really important. The challenge in stakeholders, like Anna said, although we thought we had a good spectrum of individuals represented, we really would have wanted more, and if we had more time, we would have tried to work in to have more representation of self-advocates with intellectual and psychosocial disabilities in particular. For example, though, there wasn't actually a national organisation of people with intellectual disabilities that we could ask to attend, and we were really asking people to attend on an organisational basis, not just on their personal basis. We wanted people to have a community behind them that they could bring with them and that they could share the knowledge that they were getting with. We are, in the Centre, along with Inclusion Ireland, involved with supporting the establishment of a national platform of self-advocates with intellectual disabilities. But at the time, there was no way we could have, there was no organisation we could ask. So, difference of opinion among stakeholders, I mean, this reflects again what Rosemary said in the drafting of Article 12. Some people had really, really different positions on legal capacity, and some people ultimately left the process because they felt they couldn't support what we were asking for, which was a support model of legal capacity. We had statutory bodies involved, or at least attending the meetings of the coalition, such as the Law Reform Commission and the Irish Human Rights Commission, but because they were statutory bodies, they felt within their remit, sign up to the principles because they felt the principles were an advocacy issue and not something that they could do within their mandate. Plus, the Law Reform Commission had a difference of opinion with what we were trying to do in the principles, because they had to stand behind their report that they produced in 2006, which recommended the establishment of a system of adult guardianship, and they felt they had to stand behind their research and their report.
So in the interest of wrapping up, I will just share with you the other two challenges were big challenges. The scope of the reform. There were people that wanted to not include mental health was one. Mental health law was one of the major challenges there. And we don't have time to get into more, but Eleanor and I are happy to talk to people afterwards if they're interested. And the last challenge was political will. It was interesting because we had this opportunity because they said the government had promised to make this change before ratification, and it had promised ratification, so we had this door into pushing for this, but actually stirring political will to really realize the rights in Article 12 was much more difficult. And now Eleanor's just going to give you a really quick sum up of what the developments have been and where things are right now.
So basically, as we heard from Minister Lynch yesterday, the publication of the bill is imminent, and I know there are people who will sigh at that and roll their eyes, probably me included, because we've heard that so often. However, I think from what we know that it will be published very soon, and I think, but the question is, of course, whether what's published is something that we can accept, that we think reflects the principles. The good things that have happened this year, I would just say, in terms of trying to keep the focus on the need for this reform to happen, the need for it to be CRPD compliant, would be, for example, the Amnesty conference that we co-hosted with them, at which Gabor was present, and also Cher Nicholson from the Office of the Public Advocate in South Australia, which had done a really interesting pilot on supported decision making, and also a conference of the Disability Federation with Teresa Degener from the UN Committee. And I think the most important part of what Teresa did while she was here is that she actually met the officials from the various departments, and she had a private session with them where they discussed what their issues were with how were they going to incorporate the convention into the new law, and I think she gave them some really good guidance. So I have hope that there will be some positive things in the law and that we will see it soon, but I'm sure it won't fulfil all the requirements of Article 12 because we've never seen a law that's done that. But it's an interesting process, and we're happy to talk more about the principles tomorrow, or if you grab any one of us in the coffee breaks. Thanks.
Thanks, May.
So I'm Yoshi from Tokyo, And so this afternoon, I'd like to report our situation on the eve of ratification of CRPD. And I'm focusing on the cases, lawsuit cases on voting right for persons under guardianship and disability rights reformation in Japan. At the beginning, let's look over a history of reformation of Japanese disability law and policy over the last 10 years. The Special Task Force for Reformation of Existing Law and Policy is, I'm sorry. And so let's start with, overlook history of Japanese reformation of disability law and policy over the last 10 years. In 2004, Japan Disability Forum is organized. JDF is National Alliance of Organization of Persons with Disabilities and their families. And its aim is to harmonize existing disability law and policy with CRPD. And 2006, as you know, CRPD was adopted. And just next year, Japan signed it. And in 2008, change of the government was happening from a conservative party to a progressive party. This change of the political climate influenced very positively our situation. And in 2008, the headquarters for reformation of disability law and policy was established under the Prime Minister, and the headquarters organized the Committee for Reformation of Disability Law and Policy. And the majority members of this committee are persons with disabilities. And in 2010, we raised a lawsuit voting right of persons with under full guardianship. We raised a lawsuit not only Tokyo District Court, but also other big cities in Osaka, Kyoto, Fukuoka, Hokkaido, anyway, various kinds of cities. And in 2011, Basic Act on Persons with Disabilities that had been enacted in 1970 was amended. And in 2012, the government was changed again, this time from Progress Party to Conservative Party. And so this change influenced very negatively our situation. And in 2013, this year, our plaintiff won a lawsuit case. This is the first case in Japan. And in 2013, this year, Employment Promotion for Persons with Disabilities Act that had been enacted 1960 was amended. And Promotion of Relief from Disability Discrimination Act is under discussion now. The draft of this act will pass this month. So at the beginning, let's start with a voting right case. The Japanese election law had deprived the person or people under full guardianship of their right to vote, but the Tokyo District Court ruled on 14th March 2013, this year, the provision of the law is unconstitutional. And after that, the Congress amended the election law last month, 74 days after the court decision, very quick amendment. And they just deleted the provisions. So this seems to be a kind of triumph for a person with disabilities and advocates. But there are some problems. So the court reasoning is problematic. The court said that it is reasonable to require a capacity to vote. But we cannot say that a person under full guardianship is always incompetent to vote. Because a person under full guardianship is allowed to purchase daily items, to marry, to divorce, and to live his or her will by oneself. And a capacity to manage one's property is different from a capacity to vote. The court mentioned that it would be possible to establish a different capacity examination system properly for election. And the court did not refer equality of legal capacity and supported decision making. So what is the prime premise of this adjudication? A diversion of guardianship into an election is just unconstitutional. Court says diversion is unconstitutional or unreasonable. But it is reasonable to require capacity to vote. And some persons with disabilities may be incompetent to vote. Then it will be constitutional to exclude a person with disabilities who is teleologically examined to be incompetent to vote. Since the purpose of guardianship is different from a purpose of election, capacity assessment of guardianship is of course different from capacity assessment of voting right. Then, if the government develop a new capacity assessment system properly for voting right, the court will regard it as constitutional. So there are some misconceptions on capacity in Japan. So general public or the government or the court only analyze a capacity from a purpose of legal system. And they lack an aspect of social factors that support a human decision. And the government may establish a new capacity examination system to vote, though they simply deleted the provision at this moment. So this is a very problem. We are afraid of this. And there are some problems on legal capacity in Japan. So existing systems are strongly based on medical model, especially guardianship system or involuntary commitment hospitalization system are very much based on medical model. And the judiciary and the government do not recognize supported decision-making method. An existing system too much leans toward guardian system and institutionalization. And the national budget is partial toward hospitalization. Please look at this table. This table shows ratio of full guardianship. So Japanese civil code provides 3 types of guardianship. One is total or full guardianship. It limits capacities of award totally. And the number 2 is half full guardian or half total guardian. It sounds curious, but it limits capacities of award in certain legal categories provided by civil code, such as contract of real estate, contract of important asset, or succession, or lawsuit or debt. So partial guardianship limits capacities of award in a few legal categories that are selected from these 13 legal categories. But as you know, so the total guardian is almost 80% of guardianship. And partial guardian is just 3%. And half full or total guardian is almost 20%. And so court decision very much lean toward full guardianship. So the family court examine a capacity and appoint a guardian, but they easily use guardianship and lean toward full guardianship. lots of lawyers and social workers in Japan do not regard a guardianship as a last resort. They believe a guardianship can protect a ward, and a full guardianship is very powerful and convenient for them. This table shows numbers of involuntary inpatient, 2 million general population in Japan. It is obvious Japan precludes among other countries. How about this national budget data? This shows national budget for mental health and welfare. And astonishingly, 97% of the national budget is spent for medical treatment. And the budget for community living is only 3%. On the other hand, hospitals get 70% of the national budget. These tables show that Japan is the most institutionalized country. So let's go to the next theme. So new Disability Discrimination Act, victory or half victory? I'd like to use half this time. So Japan Disability Forum, JDF, had worked to harmonize existing disability law and policy with CRPD since 2006. And the government enacted 3 acts. Number 1, number 2, number 3. So how about Basic Act for Persons with Disabilities? This act was enacted originally in 1960, very old act, and amended in 2011. And the act defines disability based on social model. So this old act defined disability based on medical model, but in 2011, the definition was changed, reformed. And it provides an anti-discrimination provision, and it provides a reasonable accommodation provision. So this seems to be a kind of victory, but there is a problem. The anti-discrimination provision and reasonable accommodation provision are not based on civil rights, but on a political obligation. I'll explain it later. And they are interpreted as just principles of administrative policy. And the anti-discrimination provision is just a single, simple provision, not comprehensive provisions like ADA. This table shows the kind of structure of this law. So Basic Act provides political obligation for the national or local government. And the Act provides also principles of disability policy. But this law does not provide civil rights or human rights or anyway rights for persons with disabilities. Then a person with disabilities cannot raise a lawsuit directly based on this basic law. This is a problem. How about promotion of relief from Disability Discrimination Act? This law sounds literally in English very curious, in Japanese very curious. But this act provides authority and responsibility of the government to promote relief from disability discrimination. And the government has to provide guidelines to promote relief from disability discrimination. And the government has to listen to opinions of persons with disabilities when elaborating a guideline. And the Act requires to establish a committee on disability discrimination in the government and every municipality. And the committee run a kind of mediation system, and they gather information about relating to discrimination. But this is also the structure of this law. So this law provides obligation, but of the entity, But this obligation is to the government. And the government provides administrative guidance or land mediation. But this law does not provide any civil right or right to persons with disabilities. And so a person with disabilities can ask the committee to start mediation, but they cannot raise a lawsuit to the court based on this law. So this is a very much limited law, and so this is a problem in Japan. The public sector has a legal obligation to abide by this guideline, but the private sector does not have any legal obligation according to this law. So this is another weak point of this law. Okay. And conservative lawmakers try to avoid admitting civil or human rights to a person with disabilities. This law was enacted just after the change of the government, 2012. So the power of law is made weak. And their aim is to protect majority from litigation by anti-discrimination law. How about Employment Promotion for Persons with Disabilities Act? This act was enacted in 1960, so very old one, but amended this year. And this act originally provides a quota system for persons with disabilities. So this law is a kind of social welfare law, but it adds anti-discrimination provisions and reasonable accommodation provisions in an employment field. And the private companies have an obligation towards the government to abide by those provisions. And if a company does not follow those provisions, it will get administrative guidance or administrative order, or they have to pay fine. And the Act provides a mediation system too, which is composed from representatives of employer and employee and the general public. But a person with disabilities cannot raise a lawsuit directly based on these provisions, claiming discrimination or reasonable accommodation, because an obligation of an employer is not an employee with disability, but to the government. The structure is almost the same. So obligation is just to the government, and the government will provide order or land mediation. But a person with disabilities does not have any right under this law. So there are 4 types of discrimination law, anti-discrimination law: criminal or constitutional or civil or social welfare model. And Japanese Anti-Discrimination Act now are sorted into a type of social welfare law. And they are not civil rights law. And they do not give persons with disabilities rights, but expect the government to play a paternalistic role to protect persons with disabilities from this discrimination. So even so, there are some advantages in this law. So this law can raise the standard of equality and reasonable accommodation in general. And it will provide easy, inexpensive, and speedy solution for persons with disabilities, and also for discriminators. But there are some disadvantages. So an individual with disabilities is not guaranteed his or her right, and the guideline or standard cannot fulfill every individual need. This is not tailor-made. And it is difficult for persons with disabilities to demand an individualized reasonable accommodation by judicial procedure. My conclusion. So the reformation of the election law was one of the most marvelous success, but its way of thinking is still based on medical model, and they do not come to realize that a human capacity is mainly based on social factors. And we need to accomplish paradigm shift on the legal capacity. And we have to push the government to enact a civil rights-based Anti-Discrimination Act. Otherwise, persons with disabilities in Japan will not have any power to control his or her life. Thank you very much.